Hello friends, how are you? Myself is Dr. Jinesh Soni. I am an advocate, regular active practitioner, and today I am going to discuss an important judgment concerning Prevention of Corruption Act. But I will discuss the said judgment in the practical way so that you could understand the logic, you could understand the concept and could apply the same in your own case, at your own level. So relying on an advocate is a good thing. But relying absolutely is totally fatal for your legal health. Always remember that before consulting an advocate, we all are expected to do the proper research of our case. We are expected to do the research of citations that might be applicable to our case. And apart from that, we are required to have the microscopic analysis of the facts of our case so that we could have effective discuss. Because whenever we are going to consult an advocate or an expert, the things are different. Because if you are going to an advocate, he might understand your case, he might have certain interview of you to understand your case, but expert require the pinpoint query. Expert requires the specific question. Expert require the specific query. And to conclude the same, you are also expected to do the homework so that effective conclusions could be drawn and you could have the optimum remedy in your case. Do you want to learn how all such things are possible? Do one thing, have a notebook and keep a pen or a pencil with you and narrate the points which I am going to specify. First of all, we have to note down the name of case. Name is title of case. Case title is State of Maharashtra versus Prakash. Judgment date is 2nd of May 2025. It is pronounced by Honorable Bombay High Court. In the said case at hand, the accused had been prosecuted as per Section 7, Section 13, Subclause 1, Subclause D of PCA. Please remember that and be aware and be alert and be updated. After 2018, the use of Section 13, Subclause 1, Subclause D is on minimum side. Most of the states are not using it. And apart from that, in state of Haryana and state of Gujarat, Section 13, Subclause 1, Subclause B is imputed in place of Section 13, Subclause 1, Subclause D. But the key point is that Section 7 of PCA is important, and to sustain Section 7 of PCA, the prosecution is required to prove the demand. If demand is not proved, in that scenario, the accused could not be prosecuted, even convicted. Dear viewers, every case has its own story. The story of present case is that the concerned complainant claimed himself to be an agriculturist. He submitted that to avail the benefit of crop insurance scheme, a scheme launched by central government. He inter alia communicated and found that certain documents are required. Finally, he communicated with the accused and requested for documents, and concerned accused directed the concerned complainant to meet again. In this way, days had been lapsed, but the concerned complainant failed to get documents. And finally, the concerned accused submitted that if the concerned complainant is willing to have document, then he has to pay rupees 200 as bribe. Rupees 100 right now, rupees 100 when document to be delivered. Ultimately, he submitted a report to the concerned Anti-Corruption Bureau. A report is usually called Tapas in state of Maharashtra and state of Gujarat. After that, pre-trial proceedings had been done. During the course of trial proceeding, the accused was caught red-handed. Finally, he was prosecuted by the way of charge sheet. Finally, charges had been framed. The prosecution inter alia offered the testimony of complainant punch witness as a star witness, and apart from that, the testimony of TLO and IO had been offered. After closure of statement of the prosecution, the statement of accused had been recorded, and finally, he was acquitted by the concerned trial court. We must remember that there is a presumption of Section 20 of PCA as far as Section 7 of PCA is concerned. But having the presumption does not mean that the concerned prosecution is totally relieved from its duty to prove the case beyond reasonable doubt. If there is a presumption, in that scenario, you are required to review the same. And you are expected to have a theory in your mind that is called theory of preponderance of the probability. And relying on that theory, we must contest our case on the touchstone of principle of probable defense. Means we have to create certain doubts. Means we have to submit certain circumstances that might create doubt in the case of prosecution. And if we are totally able, in that scenario, we could be succeeded. To rebut the presumption, it is not necessary for us to come in witness box. By doing the lengthy cross-examination, by impeaching the credit, and apart from that, by bringing the inconsistency on record, we could easily rebut the presumption. Okay, now? So in the present case at hand, the concerned accused has raised multiple probable defense. Defense number 1, he submitted that in another case that is booked by concerned TLO, one of the public servant had been trapped. In that case, the accused of present case was a witness. In that case, the concerned court rejected the case of prosecution. And ultimately, concerned TLO is of view that due to witness examination, means the testimony of concerned accused, the concerned case had been damaged, and that's why he developed serious animosity. And ultimately, he planned and finally trapped the concerned accused by hatching conspiracy with the concerned complainant. Although that defense was taken by the concerned accused, and in support of the said contention, he submitted the proceeding of that case, means the case in which he was a witness. But we have to be very much careful and must remember that if we are raising a specific defense, the burden is on our shoulders. And regarding same, you may read section 106 of Indian Evidence Act. Apart from that, he is having a straightforward case. Neither demanded nor accepted any money. He emphasized that the basic ingredients are not satisfied and even established by the concerned prosecution agency. He submitted that to sustain the prosecution under section 7 of PCA, it's a duty of the concerned prosecution to specify that the accused is a public servant. And being a public servant is having a public duty, means there is a pendency of work. He abused the official position to give any benefit to the concerned complainant, or he was in a position to forbear to exercise duty which he legally bound to exercise. In that scenario, if all the ingredients are satisfied and established, the concerned accused could be convicted. You got the point now? So he submitted that as far as the case is concerned, the demand is of rupees 200. In the first part of story, it is submitted that I had taken rupees 100 as advance, but there is nothing on record to sustain the same. Even there is no charge. And apart from that, my straightforward defense that I neither demanded nor accepted is supported by the testimony of complainant. Sometime there is usual question from your side. The complainant had deposed that accused not demanded, even not accepted, and inter alia money was offered by me, and inter alia it was put by me on the table of the concerned accused. Accused totally refused and even directed me to take back the same. Whether such a statement would help us? Answer is in affirmative. If the concerned complainant turned hostile, and even though he becomes unreliable, in that scenario you could have the benefit, because such a scenario inter alia germinate. The point of inconsistency, in that scenario the testimony could be affected, the story of prosecution could be affected, and we could have the benefit. In the present case at hand, the concerned accused submitted that the concerned complainant had received a document. I had not taken any money from him as a bribe, and the said point is duly sustained by the complainant. And apart from that, there is a punch witness who inter alia alleged to have the observation of the said conversation. But in his testimony, he specified that he neither seen nor observed the said proceeding of conversation, and the said fact is indicating that there is no active corroboration. We must remember that even on sole testimony of the complainant, the accused could be convicted. But if there is any inconsistency, the story is doubtful, and apart from that, there are certain laches in the case. In that scenario, the said testimony could not be relied in whole. It is required to be duly corroborated. So if there is no corroboration by the punch witness or by the shadow witness, the accused could have the benefit. Apart from that, he submitted that when there is no demand and even demand is not sustained, the accused could not be convicted. He relied on multiple judgments. And apart from that, he submitted that when the ingredients are not satisfied, in that scenario, no presumption could be drawn, and even the accused is not bound to put the contrary evidence because the basic evidence are not available on the record. So looking to the facts and circumstances, the accused had been acquitted and the said acquittal had been upheld by Honorable High Court. So the said judgment inter alia guide us about the three important points. First point is that demand is sine qua non. Number two, mere recovery is not sufficient. And number three, if the testimony of complainant is inter alia not found to be reliable in whole, it requires active corroboration. If it is not corroborated in whole, or the concerned witnesses are not going to corroborate the same, in that scenario, the concerned defense could have the benefit on the board. So I think that this is an important judgment. Please note down the same, make proper notes and apply the said principle in your case and make proper notes. In light of same, I am going to repeat the same again and again by doing the specific emphasis. For this, read the report, read verification report, read transcriptions and find out the inconsistency. If you are able to find, in that scenario, you are going to put shadow on the case of prosecution and you are going to give power to the theory of probable defense. So with these words, I am going to conclude my class. See you in the next video. Till then, Jai Hind, Jai Bharat.